Ladies and gentlemen, welcome back. We will now proceed to the IP Open Policy Meeting for the Cooperation Special Interest Group. In this session, we're going to focus on data privacy, security, as well as content filtering and censorship. The moderator for the session is Ms. Joy Chan, Deputy CEO of TWNIC. Ms. Joy Chan was the Deputy Director General at Cybertrust Technology Institute of the Institute for Information Industry, where she conducted research on IoT endpoint security and device identity. Ms. Chan once led the research and development for Yahoo products and services and has extensive service experience with many large firms in the US, including IBM and Dow Jones. Her expertise lies in both software development and systems operation. I will now hand the floor to the moderator for the session, Ms. Joy Chan. Ms. Chan, over to you.
Thank you very much. Good afternoon, everyone who is in the room with us, and I'm sure there's many of us offline and somewhere in virtual. So I want to welcome you for this session. This session is named Cooperation Special Interest Group. And the reason that we have this session is because we know in today's internet, everything is connected. And there's so many different relationships and partnerships that we have to work with each other. So today, in this, in the ICANN, APNIC, TWNIC engagement forum, we want to talk about data privacy, data protection, and security, and beyond, because everything is really tied together. But when we use the internet, we realize that all the information that flows, that connects to each other. And there's a lot of the data privacy issues that are happening around the world today. So we're going to use the next hour to talk about it. And the way that I have organized this session is really having my wonderful panelist speakers who's going to give us a lot of examples and different scenarios so we can see what's happening. So I'm going to spend some time just to tell you how we're going to go through this session. First, I will have to ask my very good friend, Gen Ying. Gen Ying is a practice lawyer from a very prestigious law firm, Lee & Lee. And she has entered the data privacy area way early. So she knows many of the things and develop and evolve in the Taiwan situations. So hopefully that she can tell us what's happening here in Taiwan, give you some trend. And then I also have an online speaker, Maria Cecilia. She's coming from Philippines. So she works for COO. She's pretty much like Gen Ying. She works at the law firm, and also that she's practiced one of the pioneers in Philippines talking about data privacy in the social networking. So I'm going to be very sure that you're going to see the difference between how we operate here in Taiwan, as well as Cecilia sharing from her Philippine stories. And when we talk about data security, we having wonderful Jamie here. Jamie is being a very popular speaker. I found out that you are on the stage a lot today. So Jamie is going to be sharing with us from the security point of view, where he entered when incident happens, when data security advices are seeking from his advice. So I think that's going to be wonderful. And the last but not least, my very honorable Judge Henry. Henry Tsai, very different. He's been ruling from the, I think, intellectual property court, and he has seen many things. So I want to see from his understanding and his experience, how much he can share with us. What are some of the thoughts and cases that he can share? So I'm going to leave that to the last to Henry. And I may have a surprise for you at the end of the session. So let me stop here. Without further ado, I'm going to pass the floor to Gen Ying. Gen Ying, why don't you take the floor? Thank you.
Thank you, Joy. It's also my pleasure and honor to be here today, especially the topic and the question that you gave me. It's kind of introduce my lawyer's life. It's because Joy gave me the assignment to introduce Taiwan data privacy law and its involvement. And we must recognize that Taiwan is one of the few countries that has a data privacy law at a very early stage. Our statute was enacted at the beginning in 1995. I started law practice in 1996. And the law, before it applies to only 8 industry, not each of us, and it only apply to computer processing of personal data. So at the beginning, early days of my practice, the clients are always joking that if we want to get around the data privacy law, we just use a pencil and take down all the personal information, then we will not be bound by the law. That was the old days. And in 2012, we have a significant amendment to our data privacy law. The law was expanded to be applicable to each and everyone, including each company and each individual, and including all types of data processing activity, including using computer or using pencil. So nowadays, people are more cautious about collecting personal data. And I also see the different attitude from clients. Before, most of the clients want us to think about some way to get around all the restrictions on the data privacy law. But now, I think the client is still asking similar question or to similar angle or perspective, that how they can get more data, how they can share more and generate more profit by using personal data. That's still the trend and direction. But some of the clients will ask me prerequisite question is whether my company protect personal data enough, whether the protection measures that we are taking are sufficient. So they will look back and self-revisit whether they have been respect privacy and personal data sufficiently. So I think that's a very huge jump and a very different trend, especially when those questions were raised by younger legal professionals. So I believe that at least in Taiwan, people are focusing protection of privacy more and more, and that's already something built in the system and building in people's mind. So that's a very important changes. And there's, because today we are at the TWNIC ICANN engagement forum, so about any major cases showing the different trends of protection of privacy, I believe ICANN is another most prominent case. That is the WHOIS database. The early day I started law practice, I'm also an MMA lawyer, so our daily job is to do legal due diligence for clients. So where we can get information, we just look up WHOIS database to see whether the domain name is owned by a certain company or certain person, to make sure that the buyer gets the right and lawful entitlement to a certain website. But now, if you look up to WHOIS database open time, you just see the privacy policy or certain company service name, and you cannot get the full set of data. That's the, I would say that's probably the most important changes in privacy and the personal data protection against computer science, because WHOIS database was originally designed for each domain can contact with each other. So we need to know the contact information of each technical support staff. But later on, it becomes something like the IP right owner and the law enforcement, they can go after too if the website are doing anything illegal or they are infringing copyrights or other rights. But right now, because I think the society, both the Internet Society and the ICANN Society community, they recognize privacy. So WHOIS data, they made changes to WHOIS database in the way it is. Of course, I believe GDPR from Europe is another driving force. But at least now we get used to such kind of WHOIS database, and ICANN is going to launch its very first, very hard to remember the name, pilot program for registration data request service, RDRS, in the second half of this year. So we can see how WHOIS database will be show its new face later. But it's really a very important example to show us how the internet society started to respect privacy and the personal data. And locally, there are certain other cases that also showing the same trend. But also it shows a conflict or interplay between different values, especially between privacy and other values. For example, in Taiwan, we have this right of forgotten case. A certain person has been suing Google for so many years. The case is still being heard by the Supreme Court of Taiwan right now. And this person was reported for doing something bad. I don't want to repeat his name and what he did because he wants to be forgotten. And he has been trying to ask all the news media to take on their original report and the links. But he failed because the Taiwan court thinks that protection of freedom of speech and the freedom of press is more important than his privacy. And then he sued Google, asked Google to take down all the link to the original source. And he hasn't been successful for so many years. But until I think last year, one of the layer of the court changed the mind. They think that because the incident was kind of old, it's a historical story. It's like more than 10 years ago, maybe 15 years ago. And the judge asked the society and the others whether it is so important that we need to remember this incident. If all the source will not be taken down, why not just Google take down the link? So that's the question asked by one of the Supreme Court judge, I believe. So this case, there are some different angle putting in, and so this person continued to file a appeal to win the right to be forgotten. So here we can see that in the past, we think that privacy is not so important and the other values are more important. And whenever there are controversy or conflict, maybe the other values will prevail. But over time, the justice and the courts and the society changed their mind, and we now respect more about privacy. And then this year, I think this year is a very important year. We can maybe call it a turning point year for Taiwan privacy professionals, because just on the 6th of May, the Legislative Yuan just enacted our amendment to our Personal Data Protection Act. There were only two major points, but two very important points. One is Taiwan is going to have an independent government agency as our DPA. In the past, the privacy matters was regulated by different authority, by sectors. So there's no one government agency in charge and supervise everything, and there's no independent review against government itself. The government can do whatever they do. And then, of course, I'm not so sure whether this DPA will supervise government, but at least we will have one agency with all the delegation and the power to regulate privacy matter. And we were told by the government that this agency, there will be a preparatory office for this agency, and the office will be formed in August this year. And also, this amendment has another major amendment. It's because starting from this year, there has been many personal data breach incidents. The rental car companies, bookstores, online platforms, they all are claimed for leaking personal data, and there are many scam cases, fraud cases. And so the government increased the administrative fine for private business if they do not take proper security measures to protect personal data, or if they do not comply with the reporting requirement, then they will be impose administrative fine, and they increase the highest fine. So now the fine is up to 1.15 million new Taiwan dollars. Of course, this is compared to the GDPR, that's 4% of the year and the global turnover. This may be a very small potato, I mean the fine for Taiwan, but that's a very important start for us because before it was only 500,000 new Taiwan dollars. So that's a very important and progress on that. So I see that this year is a very important turning point years for all of us. So I think the future is bright and we will continue to protect privacy in Taiwan.
Wonderful, wonderful. So there's new laws that's happening. There's the case that you mentioned for the law of forgotten, which people may have different view because even though it's been, you say, more than 10 years, but people still fighting for that. And I guess that's a new agency that the government is forming. Okay. That means that there's more opportunities, I guess, for everybody to really look into that if there's any controversial issues with the data privacy and everything else. So that's wonderful. That's a very good introduction to what's happening here in Taiwan. And this year, as Gen-Ying says, this is a year to be remarked. And I'm sure it's going to be, as you said, more bright futures. Okay, I'm now going to turn the switch over to Cecilia, Maria Cecilia. She is online with us, and she has, as I said earlier, she has been working with COO also from the data privacy side of it. And she's also considered as a pioneer in her area. So if you are here, Cecilia, why don't you say hi, and let's hear from you and your story and what's happening in Philippines in relatively compare with what Gen-Ying has said, and also your view as far as you can see where everything is going with the data privacy areas. Yes. Thank you.
Thank you, and good afternoon. Again, I'd like to thank the organizers for inviting me, and also thank you, Joyce, for the generous introduction. So I was listening to Gen-Ying's presentation, and I could say that compared to Taiwan, Philippines is actually just a teenager. When it comes to data privacy, we enacted our Data Privacy Act back in 2012. So it's a little over 10 years since we had our law, except that in the case of the Philippines, the implementation of the law actually started just in 2016. That was the year when our regulator, the National Privacy Commission, was finally organized. It was only also during the time when the regulator was organized that implementing rules and regulations were drafted and issued pursuant to the Data Privacy Act. So before that, we didn't really have a lot of legislation dealing with privacy, although it is a recognized constitutional right in the Philippine Constitution. But of course, the idea under the Constitution is a bit more different from what we now understand as the right to privacy, because data privacy primarily, I think, deals more with information privacy, whereas when it comes to the recognition under the Constitution, it was really more of privacy of communication, as well as privacy and security in your personal life and in your home. Now, when it comes to the implementation of the Data Privacy Act in the Philippines, in the first few years, the focus of the regulator was more on educating the people. As I said, we didn't really have, when it comes to laws at least, we didn't really have a history of privacy legislation. So from the beginnings, when the regulator, when the National Privacy Commission or the NPC was focused on educating companies, educating people about their rights, we now are seeing a shift in the last 2 to 3 years. We have been seeing a shift, and the NPC is now focusing more on enforcement. And one of the clear indicators of this is that in December 2022, the regulator finally issued a circular on administrative fines. So now, aside from the civil and criminal penalties that are available under the law, we already have administrative fines in place. And administrative fines are actually nothing to scoff out because it mimics the framework under the GDPR in the sense that the penalty is also pegged on the gross annual income of the company or the organization. So in the Philippines, depending on the type of offenses that are committed, the range is from 0.25%, that's 0.25 up to 3% of the gross annual income. However, after there was really a lot of outcry as well on the part of the organizations because the position was that this also created a big disparity between smaller organizations and bigger organizations, such that the effect would be a big organization that could commit, just a small infraction may end up getting fined much, much more than a small organization that really committed a major offense. So as a concession to that, the regulator established a ceiling of 5 million. So regardless of how big your income is, it should not, the fine should not go beyond 5 million pesos. We are also seeing that's on the regulator side. When it comes to the organizations, we are also seeing a lot of organizations now have achieved maturity in the privacy operations. So now we have a lot of organizations that not only have their data privacy or data protection officers, but they already have in place privacy units, whether this be centralized or whether this be embedded personnel in each of their operating units. So we are seeing a lot of that. We are also seeing, when it comes to the citizens, a lot of awareness as well on their rights as data subjects. So for instance, in the company that I work for, which is a telco, we have been seeing an increasing number of data subjects, our customers, also members of the general public sometimes, that have been writing us asking for more information about how we process their information. Some have actually become more sophisticated in the sense that they know now that they have rights to object to the processing of their information. So we're seeing a lot of that as well. And of course, while we can appreciate, where this is coming from, because this is a recognition of the maturity as well of the Filipino people when it comes to looking at their privacy rights, from the perspective of the organization, responding to this request, it has also become challenging because we also have to keep pace with the maturity of our customers, of our data subjects. And then apart from that, we are also seeing that privacy is increasingly becoming an important standard by which to measure companies. So as you may know, privacy is one of the pillars when it comes to ESG investing. And in the Philippines, our Securities and Exchange Commission already requires listed companies and public companies to submit a sustainability report. And one portion of the sustainability report deals with customer privacy. So on an annual basis, we are required to report to our Securities and Exchange Commission our statistics when it comes to customer privacy. This would involve the number of breaches, if any, the number of customer complaints, the number of regulatory actions in respect of customer privacy rights. And then finally, when it comes to trends, I noted earlier, Kenying was saying that the number of data breaches has become a challenge when it comes to Taiwan's privacy implementation. So it's also the same in the Philippines. So in the past 2 years, I think we have been experiencing a lot of phishing, smishing attacks, a lot of online frauds. So this has posed a challenge because usually when we have cases like this where there are a lot of victims, and these are making use of technology, we get a lot of pressure from law enforcement and also from the regulators to respond and to protect the users, the civilians from these kinds of frauds. But at the same time, how do you keep on protecting the privacy of the Filipinos? Because for instance, in the Philippines, in response to the rising incidents of smishing, our regulator, na National Telecommunications Commission, has issued a rule stating that telecommunications companies should work to prevent the dissemination of malicious links via SMS. So that has been a challenge. One telecommunication company actually also went to the extent of banning, at least within their network, all clickable links in SMS. So, this, while a certain sector of society is appreciative of these actions being taken, of course, other sectors of society are also questioning whether this is something that impairs their rights as a citizen to be able to communicate in the way that they see fit. Another issue that is also gaining more incidents in the Philippines is online sexual abuse and exploitation of children. So our lawmakers are also, we already have a law in place, but our lawmakers are also very much looking into more ways to ensure that distribution of these materials are limited. And again, necessarily, this also impinges on the exercise of other citizens of their privacy rights, especially in terms of the material that they are also able to consume and distribute online. So basically, it's really a question of competing rights, between different sectors of society. And then in addition to that, and my final observation is that even as the regulator is now moving towards more enforcement, becoming more stringent in its actions towards the private sector, we are still not seeing, I would say, in my opinion, enough compliance when it comes to government offices. So that is also a challenge. We are observing when hopefully within the next few years, more and more of our government offices are also able to catch up to the maturity of the privacy operations of the private sector, so that they could also provide ample protection when it comes to the privacy rights of citizens. So thank you. I'm looking forward to our discussion later as well.
Wonderful. Thank you, Cecilia. From Genying to Cecilia, we see some similarities as the globe turns more attention into the data privacy. Individuals and the companies also are aware that they have their rights about their data privacies. They can ask you to forgive the rights. They can ask you, what do you want to do with my data privacy, with my data? So people are aware of it. And with everything that's happening with all the incidents, data breaches and everything, I think that the first thing come to my mind is really that, what do you do, Jamie? You obviously is not a lawyer, right? So, but you are involved when incidents happens, when people question about data privacies and what are some of the incidents and data security. How do people protect that? I think all sorts of different questions come to you. And where is your entrance point that when you see issues like this? Because this is definitely not something that people can sometimes resolve by themselves. So give us your view and share with us more. Thank you.
Thank you, Joy. Yeah, it's really quite interesting from a data privacy and protection point of view, because you have the two sides. You have the individual customers, consumers, and users, but then you have the businesses as well. From a business perspective, I think too many businesses for too long have been playing fast and loose with data collection and privacy. to the point where, I like to use the word hoarding, that they are hoarding data. They are collecting it. They are being indiscriminate in what and how much they are collecting, and they are not getting rid of it at all. It's led to many security professionals saying that companies should be doing a spring clean of the data that they are collecting. And that's just going back. That's to mitigate the current risk that organizations have by having too much data that they no longer have a legitimate and valid use to have, to the point where most consumers would not expect that these companies would be holding on to this data still. Something else that then companies should be looking to do more proactively and into the future is they should be looking to limit the data that they are collecting and ensuring that there is only a valid reason for what they are collecting and how long they collect it for. So much that, internally at APNIC, and other companies should be doing the same, they should be asking the questions when they are developing a data collection mechanism and saying, what is the reason why are we collecting these points of data? And if they cannot justify that internally, then they will not be able to justify that externally. And they should be justifying, they should be explaining to the consumers why certain pieces of information are being collected, for what purpose, and how long will they be keeping that information. Consumers should be demanding this of businesses, especially with it coming to light with all of the major data breaches that are happening right now. In Australia, just a few months ago, we had the Optus mobile telecommunication company. They had a massive data breach. From a technical perspective, it was a very small hole that allowed a flood of consumer and customer data to be sent out. This was a small test web server that was set up that had API access, that was not rate limited. You could request as many pieces of information. They were sequentially numbered. So if you saw record number 5, you could just change it and say, give me record 6, 7, 8, 9, 10, and up. And this was leading to production consumer data. This was the full database. This was not a test server. This was not anonymized data. This was everything. And telecommunication companies have a regulatory requirement to collect information to identify the consumers properly for legal purposes. So they were collecting driver's license details, sometimes even passport details, especially for people that were not having Australia as their home residence country. This information combined together was then extracted by the malicious actors in this case. This was a very serious issue. Optus, I believe, is the second most popular telecommunication provider in Australia, affecting probably about half of the population. What was very interesting is shortly after the Optus data breach was then a private health insurance company called Medibank. They also had a data breach. Medibank is one of the largest health insurance providers in Australia. So if you weren't affected by the data breach from Optus, you were probably affected by the data breach from Medibank. So this got every single person in Australia to be acutely aware of their information. This had a huge flow-on effect. If your driver's license information was leaked, it could then be abused for other purposes, and all the way up to identity theft. From there, everybody was lining up to their state agency to receive a new updated driver's license. Some of the driver's license registration boards were not expecting this many people to come forward. Some didn't even have a process for renewing a driver's license. They said there is no process. You must wait until it expires and then get a new one. So processes had to be changed, again, by pressure from the consumers, saying that more had to happen from there. So an interesting thing that how is a telecommunication company or any other regulated body supposed to be dealing with data collection. They were supposed to collect this information. Legally, they had to do it. So we need to look at changing what these requirements actually are. You know, if you look for financial fraud and for, funding terrorism, we have the Know Your Customer system, or KYC. That basically does a identity verification check that returns a token that says, yes, identity has been checked, but you don't have to store copies of personal data. You don't have to store all of this very sensitive information in one honeypot of a location that is the prime target for attackers. So, we need to push back on regulatory bodies, on the government, to help businesses only collect the information they are supposed to be collecting and that they legitimately can hold on to. Something else that I had on here is, making sure that you are also asking permission for the collection of this sorts of data and what it's being used for. A lot of organizations are getting better at this, but even for simple conference registrations, we're seeing a lot of information being collected and you don't know how long that data is going to be held for. Now, this can be difficult. You just want to attend a conference. You just want to sign up for a mobile phone SIM card. You just want these very simple transactions. But what are you going to do? I check into a hotel every time that I travel. I have to hand over my passport. They usually take a scan or a photocopy. I don't know how long that information is going to be staying. I don't know, can I request it to be destroyed? They probably have a legal requirement for collecting this information, and that's every country and economy that I visit. So, every single little transaction, when you add it all together, it's almost like the dystopian future that you don't have privacy. You don't have protection of your own data, and yet the law says it's up to you to do the protection. If someone is abusing my driver's license data, oh, it must have been my fault to leak that information out. If someone uses my bank account information, if someone uses my bank card, oh, I must have been the one who leaked it out. If someone breaks into my house, but there's no obvious sign of a window being broken, I must have been the one who gave a key to somebody and they used it for nefarious purposes. So there's a lot of demand on the individual consumer, but so much is outside of their control.
Very, very confusing. Now that I can understand, Jamie, when every time you travel, checking in the hotel, how difficult it is. And if you want to get a SIM card, there are countries that require you to provide the identity. There are places that you can probably get an eSIM, easier than that. I'm sure things are improving, but you are right, and people might not know what exactly they have the right when other people taking our data privacy, taking our data. When I sign some forms just because I want to enter this form, I don't even know what people are doing with the data that I'm providing. So as confused as I am, or as Jamie is, I'm very honorable to have Judge Henry here. I think it was during one of the very earlier acquaintance when I met Henry, and I said, with everything that's happening, I don't know, what do you do when you are sitting in the court? Do you understand all these frustrations that we are having? And some of his comments made, one of the remarks that he said really strikes me. He says, I'm sitting there, I'm doing a lot of the intellectual property rulings during the time. And he says, I really wish that people can take some of these issues to me because I'm so excited. I want to make some rules. I want to make some ruling for that because everything is really, looking at the history and what other people has been said. So I'm very happy that Henry was Henry is a very interesting person. He also, contribute his knowledge also in college to sharing his courses. So today I'm very honorable to have him here, talking from the judge's point that what does he see, where does he see how things are happening when lawyers and the individual people like me or enterprises goes to him or having issues like this. What do you see? And I know that you have done a good job preparing some information to share with us. So the floor is yours, Henry. Thank you.
Thanks, Joy. I prepared a slide. May I move to the podium? Good afternoon, all the friends, online and offline. I'm Henry Tsai. I'm a judge. Of course, I work in the court. But I started my interest in internet governance not from the court, but from my pursuing my PhD degree in the school. And I have a very hard time because at that time, only very few people discuss about internet governance. But after time passed, now I also have a very hard time in the court because now a lot of cases come into the court because a lot of crime committed on the internet or the online dispute or the data privacy issues all coming to the court. So today, I would like to share some new developments of personal data protection in Taiwan court. And because only very limited time of preparation, so I prepare only 3 cases, but 3 in Chinese society already means a lot, okay? And there's 3 cases. The first one is EID case, and the second one is the National Health Insurance Database case. And the third one is line case. The line representative is here. Very welcome. And all these 3 cases all happened within 1 year. Like the first one, EID case just entered the judgment last week. So we still cannot see the whole memorandum of the reason. So I only read the press release from the court. The second one is entered the judgment at last year, but until now it's only 8 months. And the third one is the line case is entered the judgment just last month. They are all very new case and a very important case about the data protection. And let's look at the first case, the EID case. The government had the ID card renew plan. It will make us to have all a new EID. We don't have to use the card anymore or use the paper ID proof. During the April 2020, and it was going to enforce it around October 2020. So some citizens filed the lawsuit seeking injunction for not invalidating the old ID card. And the judgment made by the Taipei High Administrative Court, the case number is 数字 9/12/2020. Here is the court's holding. There is no enough legal basis to enforce the ID card renew plan. The authority to issue the ID card under the household registration law does not mean that the government has the power to make the ID card become a digital one. But however, since the government already postponed the ID card renew plan, it is not necessary to enter the injunction. So the plaintiff loses the case formally, but win the case substantially. In the press release by the court, it says the EID collect, store, and process the personal data in the digital way. The digital footprints made in the course of every time EID using are kinds of invasion and disturbance to individuals' private life. Just as Jimmy said, that when he go to the hotel, he have to turn over his passport and a lot of information on it. So if our ID card become an EID, then everyone, any entity or everyone who use the facility to read the EID, they could get something more than its purpose to do the transaction. So the court said it also gives influence to the EID owner's decision of self-control of data, personal data. It is the restriction of people's data self-control rights and the data privacy. Therefore, EID should have its own legal basis. Because at the beginning, the government think that it's already have the legal basis from the household registration law. In the household registration law, it prescribes that the government has the authority to issue the ID card. So the government thinks, since I have the power to issue the ID card, I can change it to an EID. But actually, from a paper one to a digital one, it is a big change and change the substance of the event. So the court said that it is against the principle of legal reservation to enforce the EID system only based on the current household registration law. According to the opinion of the court, the government should have a special law for the EID. Otherwise, the government cannot issue EID or change to the EID system. The second case is about the NHI database case. NHI means the National Health Insurance. Now in Taiwan, we all have the National Health Insurance. And the National Health Insurance database may be accessed by external applicants since 2000 year. Under different levels of scrutiny and researches and of academic institutions may be granted access to the NHI data per request for research purpose other than the implementation of NHI. At the beginning, we turn over our information to the NHI database. That's because we want to have the insurance. But now they took it to the research purpose. So the plaintiff, the petitioner, go to the Constitutional Court to ask the question: is the use over its original purpose, is it constitutional under our constitutional law? So the petition of this case believe that their personal NHI data cannot be legally disclosed to external users for usage other than the NHI itself, and they requested that their personal NHI data not to transmit to any third party. Of course, the government denied that their requests and contended that they have conducted sufficient data protection mechanism to ensure fair usage, and its action is for the advance of the national welfare. Oh, by the way, I have to say thank you to our judicial yuan because they prepare all the English translations for this case. So it saved my time. Okay, the Taiwan Constitutional Court Judgment Number 宪判字 13, 2022. The Constitutional Court founded that it is constitutional to collect, process the sensitive data, that is including the medical records, because the NHI have a lot of the medical records of everybody, where it is necessary for research purpose under the Personal Data Protection Law, Article 6, Section 1, 4. But it is unconstitutional. No independent supervisory instruments on data protection. It should be established within 3 years, just as the Genyin said. Now we are going to have independent supervisory instruments before August this year. It is because of this judgment from the Constitutional Court. And the court also found that it is unconstitutional that no explicit regulations on the subject, aims, and legal element, scope, and the measures on how NHI data may be preserved, processed, and transmitted and provided external. So the courts asked the government to enact a special law for it. And the court also found that unconstitutional, that no option-out regime of the usage of personal insurance data beyond its original collecting purpose. So if you don't want to have your personal data to be researched by the third party, we should have the power to say no. Okay, this is the second case. The reasoning of the court are very important. Data privacy protection guarantees the right to control personal data before, during, and after the usage of the data. The data subject right to control personal data after its usage should include the right to erasure, right to option out, and the right to restrict processing. Although it seems a very absolute right, but actually in court practice, we still have to balance different interests, just as Genyin said. Okay, now we can have our third case, the line cases. First, I introduce the background of this case. The plaintiff is the user of line service provided by the Line Corporation. The Line have a very big market share in Taiwan. Almost everyone have Line, use the Line service. The Line Corporation changed the privacy policy at September 19, 2018, and the plaintiff disagreed. Undoubtedly, if you disagree their change, then they will not provide the service anymore. So the Line Corporation terminated the service for plaintiff. Last, the plaintiff lost his 500 good friends online and many important stored materials. They all gone because the plaintiff cannot get access to the Line service anymore. On January 11th and February 23rd, 2019, the plaintiff asked for a copy of his personal data processed by Line Corporation and also rejected by Line Corporation. So the plaintiff sued for a copy of his personal data processed by Line, also asking for resuming the service provided by Line, and also 100,000 damage for emotional distress because he lost a lot of his friends. and incurred by the loss of his good friend and the stored material online. But the plaintiff lost his case in the first and the second instance, respectively in Taiwan Taipei District Court and the Taiwan High Court. So the plaintiff appealed to the Supreme Court. So here is the Supreme Court's holding and the reasoning, but only part of them. I simplify the case so that everybody can understand the case quickly and easily, especially focus on the data protection issue. So the case number is Tai Sangzhi 183, 2022. The Supreme Court actually reversed, here the typo, sorry for the typo. The case was reversed and remanded. The Taiwan High Court held that the right to access to the data under Personal Data Protection Law Article 10 only indicates those data collected, not including how the data being processed and to whom the data transmitted. It means that if the line corporation process your personal data, you turn to it. We cannot ask for those data, how they process it. But the Supreme Court reversed it, and the above holding and the reason that data privacy protection guarantees one's right to control personal data, including disclose the data or not. And if he or she decides to disclose, he also has the right to decide the time, the way, the extent, and to whom to disclose. In addition, it also guarantees one's right to know and control how the data is used. The reason here is very similar to the constitutional courts, just like I just said. So here's you can see a lot of information. The plaintiff asked the line corporation to turn it over, including all his friends and all his content of his chatting. So a lot of information the plaintiff asked, and the Supreme Court reversed the case and remanded to the Taiwan High Court. So they will continue the case. So let's wait and see how it goes. So here's my comment and response to those three cases. I think the data protection is getting more and more important in the daily operation in the court and to many kinds of cases. For example, even in the copyright case, we still have the issue about the data protection. Just like if you take a picture of others without his or her consent. So do you have the copyright of that picture? And every stakeholder in the field of internet governance, including any agency or entity in the public and the private sector, should perform its due diligence and the duty of care to data protection, following the Constitutional Court and the Supreme Court's holding and the reasoning. So we will when we balance all the interesting happen in the case, now I think the data protection, the priority will be emphasized. Thank you so much. The above is my presentation.
Thank you, Henry. I don't know how often we can hear a sharing from a talented judge here, but this definitely gives us some real cases and good scenarios. So last but not least, I asked my friend Akinori, because Akinori has been doing so much things with the piracy in Japan. Some of his comment and observations, this is throughout many years of his observation. So I asked him kindly to give us a summary about what his observation that he has seen, and the cooperation is so important. So Akinori, the floor is yours. Thank you.
Thank you very much. Thank you very much for having me here. And then this is a little bit different from the different topic from your conversation here. But I'd like to share the current situation in Japan for the anti-piracy. And then it is time to time I have shared with you. Then it is a cooperation SIG, and then I think this situation is quite cooperation. What cooperation is all about, and then we actually fought to the government's attempt to legislating the content blocking in 2018. And then at the time, the government failed to legislate that. And then after that, the government had quite a big effort to do the piracy, anti-piracy activity, and then that's quite actually the comprehensive or exhaustive list of the countermeasures, and then which is quite impressive, and then it's really worth being shared with you. Then this is a one pager of the comprehensive countermeasure lineup against the piracies on the internet, and then it's done by the Cabinet Secretary's Intellectual Property Strategy Division, and then maybe for you, you can read it here. In Japanese, 内閣府知的財産権戦略本部. Then maybe you have your own the reading of the hands. Then it is a little bit it's a little bit bigger, get that bigger, and then I'm sure that the Taiwanese people can understand the meaning of what they are meaning, and then I know that the hiragana and the katakana would be not making sense to you. Then I put the translation for that, and then this is a quite exhaustive list of the countermeasures, starting with the education of the copyright, and then enlightenment of the awareness, which means that if the younger generation don't understand the importance of the copyright, and then they don't stop the acquiring the illegal copy, then that's actually very bad for the piracy. Then it is important to educate the young people to respect the intellectual property. So that's quite an approach for the making the proper norm in the youngsters. And then the second one is the promoting the authoritative the copies circulation, and then as opposed to the expanding the use of the piracy. Then the third one is quite the fourth one. Let me go to the fourth one. It's the international liaison and the international the reinforcing the international the law enforcement, which is really trying very hard by the publishers' alignment in Japan to approach to the. For example, the many of the piracy operators are often located in Vietnam. Then they needed to the approach to the Vietnamese law enforcement agency, but it is quite hard to have them understand and then take the proper action to the piracy operators. So this is one of the key points. And then including, then also it includes that the international cooperation includes the approach at the ICANN process to have the registry and the registrar policy to properly tackle on the crime prevention. So that's included. Then the last part is the suppression of the advertisement in a piracy site. So This is a first page of the number two pages, and then you can have the lot of variety of the countermeasure, and then by the various stakeholders in quite a various direction of the effort should be taken here. When right now this countermeasure says that blocking is the last the means to take, because we pushed back to legislate the contents blocking. But if all of this doesn't make any sense, then we need to do some contents blocking by after that. So, but this comprehensive list means that sometimes blocking is done by the ISPs, and then the leech site addressing the leech site, and then contents download illegalization is done by the legislation. It is already done, and now the simple possession of the illegal copy is now deemed as the offense. So it is the law enforcement, ISPs, and then education, and ad network, and quite variety of the stakeholders are now being involved in the manga piracy situation. So this is one of the quite a good example as the multi-stakeholder cooperation for the tackling on this kind of the abusive conduct on the internet, and which is really good example to share in the cooperation SIG here.
Wonderful. Thank you very much, Akinori-san. As Akinori-san has mentioned, that this countermeasure lineup really brings up the cooperations altogether. And this special interest group, as we talked about many things today in this session, there are different elements that all this can be connected, whether that's through a dot line or solid line, but they are all connected to each other, and that they are all impacting our internet world. We're here, we try to make a better internet with our own efforts here as individuals, as enterprises, as the affiliation organization. But everything needs to be together with the cooperation, and hopefully that all this is bring us to a better world. So at this time, I want to take a pause to see if there's any questions from the floor or any comments that my wonderful panelists like to make. Welcome. And yes.
Are you ready for me?
Oh, yes. I think my panelists are.
Yeah. Actually, it really depends on what we want to talk about, the data protection or privacy, domestic or international. I think the domestic, the lawyers and the judge, Tsai already explained in Taiwan the situation. And I think it's still keep going on. I believe I think most of the people in Taiwan, we know we still have a lot of data protection and privacy issue, particularly during the pandemic year, last 3 pandemic year. The government using so-called NH car, national health car, to do something is not allowed by the national health insurance regulation. For example, the people in Taiwan, you received the 3,000 NT dollar, recently, but I don't know is the national insurance, national health insurance card, that is legal or not legal to do that, okay? There is a domestic. Regarding for the international, I think we, globally, in many of the occasionally, no matter the ICANN, APNIC, or whatever we are keep talking. I think we are talking about is in the world we are familiar with like a domestic, democratic, free countries. But to be honest, we never thinking about that is another war in the earth. They are not democrat. They are not freedom. But let's say an example like a GDPR, pass the law, pass the act in the European. And then European kind of using the GDPR, try to set up like a global standard for the data protection. But reality, if we are asking ourselves, do you think the GDPR really care by China, Russia, or I would say most of the non-democratic countries? And I like to let the people understand the situation. The reality is, under the UN, more than 190 plus country or state. But to be honest, less than 50% of them is a Democrat. Less than 50%. There's more non-democratic country than democratic countries. So when we are continue talking about in the panel or in the conference, keep talking about the data protection, we are keep talking about the privacy. That means you really left behind those of 60% of population around on the earth. How we can make a connection with that part of the world? If we are not confirmation with them to bring them in together, then I think we only talk to less than 50% of the population on Earth.
Definitely, there's different parts of the world. We try to connect with each other, but there's different layers. Gowe always has this very insightful observation beneath the surface.
The reason I say that, no matter the ICANN or APNIC, continue telling the people one world, one internet, right? But is that true?
Yeah. Sure. I guess I need to respond to Gowe's two questions. First of all, thank you for reminding me that I haven't collected my 6,000 allowance from the government. I don't know how. Your first question about the national health insurance card, I think that's, well, I haven't had the time to review all the regulation, but based on Taiwan law, each collection and process has a specific purpose. So when the card was made, there must be a specific purpose. And I think for that card, it should be written in certain statute governing national health insurance. And later on, the government expand the purpose. So if the law hasn't been amended, maybe there's a legal defect. But I believe the government is wise enough to fix that already because it's 3 years for that pandemic and for the card to be used for other purpose. But that's the basic direction if we want to look at this issue. It's the purpose of the card. But I sort of benefit from the convenience of the card for collecting my face masks and report my tax returns, and I'm going to collect my $6,000. But that's really how the people see that and how the government will treat laws, regulations, due process, and the respect that. That's my response to your first question. Your second question, I really cannot say something for China or Russia or the other side of the world, but I want to make two comments. First of all, is there anyone from US today? I believe people from EU would think the US data privacy law is nothing or less protective than the EU law. That's how the EU look at the US. Even US is being looking down on that in that respect. But for China, China has the most comprehensive data protection law. I didn't dare to say that in any public occasion because it sounds politically incorrect to say so. But their statute is the most recent one, and they sort of copy everything into that statute. So as many as you want, all the regulatory mechanisms are in the statute. If you have time, you can read that. It's in Chinese. And secondly, even Chinese company, they are evaluating outside world, whether the other side of the world are respecting privacy and personal data enough so that data can be transmitted from China to the rest of the world. That's what Chinese are doing, all the Chinese company, Chinese organization, because they have a cross-border data transfer restriction. If the outside world is not safe enough, actually they cannot transfer any personal data from China to the outside. So we have been helping quite a few clients doing that evaluation. And one of the points of the evaluation, I must say, to the democratic world is that whether the government will be looking into personal data held by private business. That's one of the very important points for the assessment. So when you say that maybe there are two words or many words and the people are tending to staying within our world. But in the meantime, I think we do need to look outside because the other side, they are doing quite a few, which we don't understand or we didn't spend time to understand. So that's my two comments.
Thank you, Ken-Ying. And I know that I'm running over time, so I ask my two people lined up to be very brief on your comments or question.
Okay.
Thank you.
I'm Chen Pen from Suzhou University. And I have a question that there's an incident that is a data breach from Taiwanese government about the household registration data breach from last year in October. And the data set included each of the citizens in Taiwan, and there are lots of sensitive data. And since the data breach incident happened, and it's over 200 days till now, and we couldn't see the administration do anything. So I would like to ask the speakers if you have any idea about how to fix this problem and protect our citizens' data.
Okay, could I ask your permission that we can take the second question first, and then we see if anybody wants to answer that very briefly. Thank you.
So my question is the ICANN-RDDS. We're currently discussing who should have access to it, who can actually obtain the data. There's no conclusion as yet. But in reality, sometimes government could use this kind of request to request information about particular website that they maybe don't like. So my question is, should government have access, should have the right to obtain this data? If not, who else can?
Thank you very much. Again, I know that I am running over time, so I ask my speaker if you can comment very briefly, and we close the session, and we can obviously continue the discussion after the break. Anybody wants to quickly respond?
I would like to respond to the first question. So we have the court, and we have the data protection law. So welcome to the court.
Thank you again. I think that we have wonderful speakers and wonderful questions, and this is a topic that probably never ended, right? Thank you.
Thank you very much, Ms. Joy Chan, for moderating the session, and thank you to all panelists. Please come to the front and to join us for a group photo. We would like to invite all panelists and the moderator to come to the front a little bit for the group photo. Thank you. And also for our online speakers, Ms. Soria, please also turn on the camera and look into your camera. We're going to have a hybrid group photo with you. Thumbs up for the photo. A big smile. All right, thank you very much. Please.